Ready? Okay. Hello, everybody. My name is Lars Johnson, and I'm the chair of the Door County Board of Adjustment. Tonight we have one case from the town of Sebastopol. Seated to my far right is Bob Ryan, John Young, Joanne Schley, Eric Weber, and representing the planning department this evening and acting as our recording secretary is Rick Brower. The process in which we will hear the variance this evening from the town of Sebastopol will be that I'll take a moment and read into the record the legal notice as it was published in the local newspaper, and then I'll turn it over to Rick. He will give us a brief introduction of the case. The applicant and or their agent is invited to come to the table and to state their case for the petition for variance. All of those in favor of the applicant's request will be able to offer testimony this evening as well. And we will take testimony from the planning department in regard to letters in favor. Then we'll ask if there's anybody that would like to offer opposition to the request. And then the letters in opposition will be entered into the record as well. As you'll have also each side will have a chance to rebut if necessary. And then we will take a brief moment this evening to render our decision when we are ready. And we do that by working on a decision-making worksheet that takes usually approximately 5 to 10 minutes for us to fill out. For those of you that aren't familiar, it's somewhat of a new process that the Board of Adjustment has implemented a couple of years ago. And it works quite well. It's also a practice of the Board of Adjustment that when you do come forward this evening, that we swear you in under oath. It is not the practice or the procedure of the board to swear in legal counsel. With that being said, I don't think I missed anything this evening, and I think we can proceed right to the legal notice. The town of Sebastopol, Gail and Muriel Johnson petitioned for a variance from section 3.5, paragraph 3 of the Door County zoning ordinance, which requires structures to be set back at least 65 feet from the center line of the right-of-way of a town road. The petitioners proposed to construct a 24 by 28, and for the record, I think that is different than the legal notice. The legal notice is 24 by 24, but the request is for 24 by 28.
Correct. Attached
garage with upper level living quarters 50 feet from the center line of the right-of-way of Evergreen Lane. This property is located at 3745 Glidden Drive in section 31, town 28 north, range 27 east, and in a single-family residential 20,000 square foot zoning district. Rick.
Right. As Lars mentioned, there was an error in the notice that was sent to the Board of Adjustment members and the general public, and the notice stated that it would be a 24 by 24 addition with attached garage addition with upper level living quarters, and it will actually be 24 by 28. And I just wanted to go on record as saying that the legal notice that was sent to the advocate and the town was accurate. The subject property is located along Glidden Drive, which is also known as County Highway T. It's approximately a quarter mile, I'll say, east of the Lily Bay Boat Landing, which is next to the property known as Wester's Fish House. The lot is located on the landward or north side of Glidden Drive and is surrounded by Glidden Drive to the south. The subject road, which is a platted, undeveloped town road to the west. There's a wetland area to the north and a single-family residence to the east. And I'd also mention now that there is a vacant lot located just west of the platted, undeveloped town road. And I'll send around an air photo that shows that general area. Now, the platted, undeveloped town road is currently being used as a driveway that serves the subject property. The only other property that may end up using the town road for access will be the vacant lot to the west. The property to the north is also zoned wetland, so there is no possibility of extending the town road in order to serve parcels to the north. Another thing I would like to point out is that the proposed addition will be set back 20 feet from the edge of the road right-of-way, which also happens to be the petitioner's western property line.
What is the right of way?
The width?
Yeah.
It's 60 feet wide. So I'm going to talk about that in a second. In most cases, the western property line would be considered a side property line. An addition would be required to be set back only 10 feet from a side property line in this zoning district. However, in that the property line coincides with the edge of the right-of-way, an addition on the property must be 65 feet from the center line of the road, which happens to be 35 feet from the western property line. And again, Eric asked how wide the right-of-way is. It's a 60-foot wide right-of-way. So to the center line, you have 30 feet. To meet the 65-foot setback, you'd need another 35 feet from their property line. And again, they're proposing to be set back 50 feet from the center line and 20 feet from their side property line. Now, there is currently a 2-story A-frame residence on the property with no attached garage, and the only accessory building on the property is a 3-foot 6-inch by 7-foot plastic shed, and I have a photo of that I'll send around. The existing residence is 20-foot by 44-foot with an upper level. The first level contains 880 square feet of floor area, and I'm not sure how much floor area there is on the second level. The proposed addition would add a 480 square foot attached garage and approximately 472 square feet of living area. I have photos that I'll send around. Again, I've got an arrow pointing to the subject property. This is the platted undeveloped town road that we're talking about. And then there's just pictures of the driveway, which is in the town road right of way, and the existing buildings on the lot. So I'll send those around. There's also a big, there's an old copy of the old plat that Laddie brought in this evening, showing the platted lots and the platted town roads. If anybody wants to take a look at that, that'll be, I mean, you see the lot we're talking about is right here in the platted town road. Actually, at one time ran all the way down to the lake. Apparently that's been vacated and relocated over to this area, and that'll be shown on that aerial photo that was sent around. But we're not talking about the lakeside anyway, we're talking about the north side of Glidden Drive. I've got that here. I also have a copy of a tax map, I'll send that around. I think that's all I have for now, Lars, unless somebody has questions.
You said that the platted, driveway platted road ends at a particular point because of the wetlands?
Well, maybe somebody here from Glidden Drive can explain. You'll see that it goes back to what's platted as a Schmoke Drive, which doesn't exist, and that all lies in a wetland area, so it never will exist. It's part of an old plat that dates back to 1938, so.
Where is the upland on the wetland to Glidden Drive and the
Where?
subject property?
Where is the upland?
In other words, the edge of the wetland.
Wouldn't be shown
I
on
would
this
say the
plan.
wetland is, I don't have an exact
Because it doesn't
measurement.
say it on here.
It's about approximately the 50 feet, the northern 50 feet of that lot, approximately. I've got, show it here. Yeah, I'll send this around.
And there is no access to their property off of Glidden Drive, it's just off of the existing drive, correct?
Well,
Off the platted road.
Off the platted road.
there's nothing existing, no.
There's nothing existing off of Glidden. Okay, fair enough.
Is there ever Is there any intention at this point by either the town or the county to pave the platted road?
I have no idea. I know it's not maintained now, but maybe somebody here can answer that.
Mr. Chairman?
You may in a moment, okay, to that as well.
Okay.
Well, okay?
Because it would only benefit two parties, correct?
It's currently not maintained as a town road.
Is it plowed?
I don't know. Not that I'm aware of, no.
And maybe council will have some,
It's undeveloped. I mean, it's an undeveloped town road, and as far as I know, they don't maintain it, but they should be able to speak to that.
okay. Okay, if you bear with me, Mr. Chapman, you'll have an opportunity to answer Eric's question as well. Okay, Mr. and Mrs. Johnson or council, do you want to come forward, please?
Do you mind if they come up with?
Not at all, please,
Okay.
please come forward to the table.
Are we talking a distance here?
That's right. Now I can see it.
This is true. Yeah, that's great.
And as you're getting comfortable, Attorney Pinker, could you introduce yourself for the record and allow your clients to introduce themselves for the record with their address, please?
Sure. My name is John Pinkert. I'm an attorney with the Pinkert Law Firm here in Sturgeon Bay, 454 Kentucky Street. And I'll ask the Johnsons to introduce themselves.
My name is Gail Johnson. My wife and I are the owner of the building that we're talking about here, and we've owned the building since 1973.
And your address, Mr. Johnson, please?
I don't hear too well.
Okay, you're-
Ask my wife.
Yeah.
3745 Glidden Drive.
Okay, and Mrs. Johnson, could you just state your name?
Muriel Johnson.
Okay, thank you very much.
Sure.
And,
Brian Nebel from Nebel Construction here, I'm the contractor.
good to see you, Brian. And do you all swear that the testimony you're about to give is the truth? Thank you very much. Okay.
Okay, thanks, Mr.
Attorney
Chairman.
Pinker, yes.
Rick gave you an excellent background of this case, so I brought some exhibits, but I see that you've got photographs and overheads and things, so I'm not gonna bother handing those out. And I'm gonna get right into the three criteria then, so we can move right along. With respect to the unique property limitations, what makes this property most unique is this road itself. This is the only property right now this is the only property that has a dwelling on this road. There's this vacant lot that Rick talked about to the west, but the Johnson dwelling is the only one on this road. That makes it unique. But for this road, we wouldn't even be here tonight. To answer the question about whether the road is maintained, it is my understanding, we went to the town level and the plan commission there, that it is not maintained. In fact, what we might expect within the next several months is some effort by the town to vacate this road. In fact, that's what dominated the conversation when we went in front of the plan commission. When Brian and I went, I gave my three criteria spiel, but the rest of the time was spent by the commission talking about how they're going to get rid of this road, really, what to do with it. But in terms of the uniqueness, that's what makes it unique. This is the only dwelling on this platted but undeveloped road, so it makes it unique. I would also submit to you that in terms of uniqueness, that this property, it's got the wetlands on the, I guess would be the north side. So in terms of putting this addition, which we propose to put on the west side of the existing structure, we're going to be putting it further away from the existing wetlands, although there's maybe 50 feet or so between the dwelling and the wetlands. In addition, there are some rolling sand dunes on all sides of this house. When I say all sides, I mean the north, the east, and the south side. So in order to put this addition on any side other than where we want to put it, it would require a substantial amount of excavating and filling. So I think the existing makeup of the property, the sand, and it makes it unique. The property's heavily wooded on the south side, and I guess this would go more to harm to the public interest, but I think there's a hill and it's heavily wooded on the south side, so again, it would require a substantial amount of excavating and a substantial amount of fill to to add this addition on the south side. There are also deed restrictions in this neighborhood that prevent the Johnsons from adding a detached garage on this property. So, in short, the most practical and efficient location for this proposed addition would be on the west side. It's immediately adjacent to the existing road. The road, as Rick said, is used primarily as the driveway for the Johnsons. They've been using it since 1973 or 1974. Nobody else uses it. It's really a road to nowhere. In terms of harm to the public interest, which is the second criteria, you can't see the dwelling from Glidden Drive. It's, as I stated, heavily wooded. I think I included some photos with the application from Glidden Drive. You can't see it. You won't be able to see this addition from Glidden Drive. There will be minimal vegetation destruction when putting the addition in on the west side of the proposed location versus substantial tree cutting to put the addition on the south side. In addition, on the north side is the existing septic system. So as you can imagine, it wouldn't be feasible to put in addition to the rolling sand and sand dunes, it wouldn't be efficient to put the addition on the north side. As respects the east side, all of the utilities are located on the east side of the structure. All of the usable space, the kitchen, I think a fireplace, are all on the east side of the structure. So that would all have to be removed. I know that's probably not something you're allowed to consider, but I think in terms of efficiency and practicality, again, the east side would not be an efficient place to put this, to put the addition. And in terms of harm to the public interest, there'd be a substantial amount of vegetation destruction in order to even get construction vehicles to the east side. And finally, with respect to harm to the public interest, there is a house, there is an existing dwelling to the east, their east neighbor. So if you put the addition there, it's possible that the addition might actually be encroaching into that setback for that neighbor. So we would perhaps have to be here for a variance in that regard anyway. Not to mention that then the neighbor's going to be looking right at this addition, and probably they would prefer not to have that addition on the east side. And finally, unnecessary hardship. As you know, as I've been here many times, and as I've told you many times, the appropriate test for unnecessary hardship is whether compliance with the strict letter of the zoning restriction regarding setbacks would unreasonably prevent the Johnsons from using their property for a permitted purpose. And that comes right from the state Supreme Court case of the Zervigal case, which we've talked to you many times about in the past. What the zoning restriction intends to do with respect to the center line of a road is to monitor the safety of traffic. What the zoning restriction tries to do is to offer a measure of safety from traffic on the town road, which adjoins this property. That's just not implicated in this case. Again, the Johnsons are the only people right now that use this road, and I suppose that if there's somebody constructs a house on the west side of the road, they would also use the road, perhaps. So at most you'd have two property owners using this road. So in terms of promoting traffic safety, that just isn't an implication in this case. So strict compliance with that zoning restriction unreasonably prevents the Johnsons from putting this addition on to their existing dwelling. The vast majority of the homes along Glidden Drive have garages. What I think the Johnsons will tell you is that they're getting close to retiring and they want to use the house as their retirement home or live here for a vast majority of the year. And as you know, the vast majority of the houses on Glidden Drive have garages. So it's a reasonable request. I think the square footage of the footprint is 880 square feet. That doesn't include upper living space. So 880 square feet on Glidden Drive certainly isn't going to be out of character with what's there. In fact, I would submit to you that it's probably much smaller than many of the houses on Glidden Drive. The 28 by 24 foot addition will add another 672 feet to the footprint. So in terms of footprint, you're looking at 1,500 feet of a footprint. Again, certainly not unreasonable when compared to the other homes on Glidden Drive. So I believe the Johnsons have met all three criteria in this case, and we would request a variance.
Okay,
Thank you.
thank you, Attorney Pinkert. John?
John, what are the deed restrictions, just for,
No detached, there's several, but one of them, in this case, would be no detached buildings, garages.
thank you.
And then in the discussions, as far as vacating the platted road, was there intention to split it off the plat or split the traveled center line? And would half go to,
Very good question, and I think what would happen is the neighbors would each be offered half, and if either neighbor declined.
half off the plat or half off the traveled center line?
Half off the traveled center line. So if one of the neighbors declined, then the other neighbor would have the opportunity then would actually almost be given the entire road.
And is it plowed by the,
No.
no?
Again, we went in front of the town and many of these people didn't even know this thing existed.
I've been on the site doing a septic test.
Okay.
Your septic system is new, right?
Yes.
Yeah, I was there
Oh.
doing the soil test,
Okay.
so I'm familiar with it, and as I was reading it, I was scratching my head trying to think where the heck it was, and I
Yeah.
saw the pictures, and then of course with me.
There was only one person that voted against us at the plan commission, and I forget what his name was, but what he wanted us to do was to take the road by adverse possession, and rather than getting a variance. And I tried to explain to him, we can't really take a road by adverse possession, but that was what he preferred that we do. So that just that tells me that he didn't even know this road existed, and the Johnsons have been occupying this thing for so long, he thought they should just file in court for adverse possession, which you can't do to a road, so.
Realistically, how long do you think it would take for the town, if they were in agreement to vacate this road? Would
Well-
it be months, years?
What happens is, because it's platted, we have to go through a court process. They would have to go through a court process, and certainly we wouldn't object to that, but it would be a matter of, filing in circuit court to do that, and
Sure.
then, so that would have to run its course, but I would say within a matter of 2 or 3 months, it
Yeah,
could be
it
done.
doesn't take long.
Yeah.
The town's done it before.
Fair enough, okay. Mr. Nebel, do you have anything to add to
No,
the construction?
that's pretty good. I know, one thing I wanted to mention though is there were a lot of structures along Glidden Drive that were a lot closer to the property lines than this one is, than what we're asking for. So, in that case, and the fact that this road, could have been vacated or maybe should have been vacated. I don't know if we want to go through that time to do that, but it's certainly a case that could have been done.
And that
So-
may or may not happen regardless of how this vote turns out.
Right.
Right.
Okay, fair enough. Okay, any other questions for the applicants? Okay, you're excused. Thank you very much.
Thank you very much.
Okay, is there anybody in the audience that would like to offer testimony in support of the variance request this evening? In support?
Could I pass
Yes,
along something?
absolutely. Please just come to the table and if you could state your name and address for the record too as well, please.
I'm Laddie Chapman, I live at 4102 Glidden Drive, and
And do you swear that the testimony you're about to give is the truth?
I do, yes.
Okay, thank you.
And I'm also the Vice President of the Glidden Drive Association this year, and I just wanted to pass along, we sent to every one of the board members the copy of the notice and said, if you have any objection, notify the planning department or tell me and I'll bring it to this meeting. No one said any objection that I'm aware of, at least they haven't contacted me for that purpose. So that's the only thing I wanted to say in favor of it. However, I wanted to perhaps clear up a few misconceptions, if I could, and elaborate on what Mr. Pinkert said. When this matter came out to the town board, rather the committee, it did kind of trigger a thought, why don't we take a blanket look at all of the lanes, at least on the inland side of the road, and decide what to do. Should we abandon them? Should we sell them? What should we do? That is going to be up for discussion at the next committee meeting this Thursday night. And I'm going to ask them to table it temporarily, excuse me, while we poll our members and see what they would like to do and bring that to the committee. And there are also property owners that might be affected by some of these lanes back in the wood side, large tracts, 40 acres, but they're adjacent to some of these lanes and they could be affected, and I think we need to get their opinions on this. Some of the things they might do is abandon any or several of those lanes by giving them to the people or selling them to people on either side. One idea is they might give it or sell it to the Glidden Drive Association because the association already owns 11 lanes along the lake. It's a nonprofit association, so we wouldn't pay any taxes on it. They might retain it as a town road. However, I think it's very unlikely to ever improve any of those. As Mr. Pinkert said, there's really no point. The Smoke Road in the back was intended to be a future probably paved road, at least developed over the time, but the lots in the back area have never been sold as separate lots, and there's really no reason to put that road in. So at least in our lifetime, I'm pretty sure that will never be developed. I would like to point a possible misconception, however, about the deed restrictions, and Mr. Pinkert's referring to ones that are attached to most of the deeds there, but they are covenants, and they are not law. And I hope he will back me up that if a covenant were objected to, it would have to be a private suit and not a government action. And there are at least 50 places I know along the drive where there are detached garages which would violate the covenants, and many of them belong to board members. I don't think we're going to sue ourselves. And the intention was to make the area look nice. And I think it looks nice even with a detached dwelling. Some people have different phobias at different times, and at one time a detached thing just didn't sit well with some people.
Well, I know I as a board member am a big fan of attached garages in R1 zone districts, in single-family residential zone districts. So I appreciate the covenant or deed restriction. Maybe it's semantics, or however you want to say it. I don't know in terms of a legal issues, but I think in regard to the private drive, from time to time we've heard about these little types of drives along Glidden Drive, and some have not this particular one, but some have shore access. Am I right on Glidden?
Yes.
And then my only thought is, and it has no bearing on this board, but my only thought is that the town board is thinking it through as well. I mean, I would imagine in addition to vehicular traffic, you have the ability to, the public has the ability to walk down public roads as well, or public drives as well. So,
if I could be a little nitpicking, there's only one that could be called, strictly speaking, public, and that's the Evergreen Lane on the lakeside, which is owned by the county. The others are either town roads, but according to that 1937 plat, they were intended for use by the neighborhood. You might interpret that differently nowadays than before, but it was not intended to be a public access. It was intended to be easy access for all the residents in the area. In fact, that's why some of those lanes widen on the beach to 3 times their width to the beach in order to make a nice beach available to everybody in the area. And John Brogan has told us, he was one of the developers of the northern part of Glidden Drive, he told us that Ewald Schmoke and Orrin Glidden planned all these lanes because their development they had in Indiana prior to this did not have them, and they felt that, quote, the backlots turned trashy, and they became second-class houses. And they decided they would not have that happen here. So they made frequent access to the water. And so the lanes in this area are owned either by the town, with one exception, county. The lanes to the north are either town or they're owned by the Glidden Drive Association. And theoretically for the association members, although we don't check membership cards if you walk down the lake.
fair enough. Okay, thank you, Laddie.
Do you have any other questions for me?
Yeah, Bob?
Yes, sir.
Do you know what happened when they relocated the Evergreen access?
Some of that is still a mystery. I spent considerable time with Mary Moore today looking up some of this information, and we did not complete the task. We know it was moved. There's a reference on there that I'll have to look up, a reference to a page, a a book and a page as to when it was done. I'll find out. I think the intention was to build in a certain area, and the lane was in the way. But I haven't confirmed that. I do know one case where that was the situation, U Lane, Y-E-W. John Brogan wanted to build a house. He's one of the developers, so he had clout. He wanted to build a house right here, and there was a lane. So he reached agreement with the two of the parties to move it over a few hundred feet, and he built his house. So
I think you may have been turned down for a variance from this board too at one time.
that would have to go back quite a few years. You may be right, I don't know.
Okay, all right. Thanks very much.
Okay, thank you.
Rick, you want to elaborate on that? No? Okay, fair enough. All right, all right. Yes, please, Carl,
Okay, yes,
come forward, please.
I'm in support. Yeah. I hope I can shed a little light on this situation.
Carl, could you do me a huge favor?
Carl Schultz.
There you go. And address as well, Carl.
3955 Glidden Drive. I've been a resident of Door County since 1951 and been involved in Glidden Drive from about that.
And let the record show that you swear to tell the truth, correct?
Oh, yes, thank you.
All right.
Yeah. And I should mention, do you know what the term Sevastopol means? That was, it's a Greek term that was applied to the city on the Black Sea a few years ago. It means a place of glory. So that's exactly what it is.
I don't know if Gibraltar wouldn't feel that way, but I understand.
It adds about 10% to the property value.
Glad to hear that.
At least I hope.
Since I reside there.
They talked about the back lots. I think maybe all of them are owned by a nature conservancy. There might be one or two that are not. Some they bought and some were donated to them. And Schmoke Road, they started building it, but it was never completed. That was to serve those back lots.
Interesting.
And there were one or two places, there's one spot to the north where they did a lot of filling and they created a big wetland. And maybe some of you, have you seen that, Rick? That big wetland, it's a nice wet area.
Is it a pond or a lake almost?
Well, there is a swale, and then alongside the swale, then the fill went to the north and created a beautiful wetland. I know that because I trap amphibians there. They're good to eat. So that's a state study of salamanders, so I'm very familiar with that. So that road actually serves no useful purpose except as a driveway.
Okay.
So
Thank
I
you,
would
Carl.
certainly wholeheartedly support this variance.
Good. Thank you, Carl.
And I appeared because several days ago somebody asked me to come, and I don't like to.
Well, I'm glad you're here because
Yeah.
it certainly adds some historical significance, so I understand what's
Okay.
happening with these
Okay.
little.
So thank you very much.
Thank you, Carl. Good to see you. Thank you. Is there anybody else in the audience that would like to offer testimony in support? In support? Okay, let the record show there's no one else in the audience to offer testimony in support. Do we have any additional letters other than the one we have from the town in support?
No, just the letter from the town.
Okay.
And they all have copies of that.
Let the record show that we did receive a letter from the town of Sevastopol in support of the variance request this evening. Is there anybody in the audience that would like to offer testimony in opposition to this request?
I'd like to, my brother.
Please come forward. Yep, and state your name and address, please.
My name is Stephen Walker, W-A-L-K-E-R, Stephen with a V, 3757 Glidden Drive.
And Mr. Walker, do you swear to tell the truth?
I do.
Thank you.
There's a point of confusion here, and I think that we exemplify it. My brother wrote a letter in opposition to granting the variance.
Okay.
And here's what happened. We live right across the lane, Evergreen Lane, that has a sign that says Evergreen Lane. right across the street from it, and it's our lake access to
That's
Lake
right.
Michigan.
Right here, this is the portion of Evergreen Lane that goes down to the water that they were talking about, right here, and this is the Walker property. right
The
there.
relocated.
Yeah, the relocated
Yeah.
portion.
And so you have this sort of confusion, is it two roads, or is it one? Because if it's one road, then there are two residences already on the road. Because there's this residence that's on the lakeside that has a driveway onto Evergreen Lane with the same general description. So talking about abandoning Evergreen Lane is a little scary because, you know, are you abandoning the lakeside as well?
Speaking from a land surveying, I'm a registered land surveyor.
Uh-huh.
If it was to be vacated or abandoned or whatever would happen, there would be a meets and bounds description written of it,
Oh, good.
describing the exact portion of what it is, even though you've got the portion that we're talking about here and the portion that you're concerned
Yeah.
about here,
They're a couple hundred feet away.
it would be in black and white,
Okay.
but that, what portion it was gonna happen to.
But this board doesn't have the authority to do that. That would
Right.
be done at the town level.
Right, well, the confusion that we experienced, I think, could be experienced by others, and I think there was some.
Absolutely.
Fair enough, fair enough.
So I'd like to remove my brother's and my objection to the variance. So you can, I don't know what you'll do
There is
with the
a letter.
letter.
Okay, that's fair, okay.
Okay.
Thank you,
Thank
Mr.
you.
Walker.
And I
Thank you.
think, as Mr. Chapman explained, from what I understood, Evergreen Lane on the south side going down to the water is owned by the county.
Yes.
So there's no discussion concerning vacating that portion.
And it's my impression that it's the town of Sevastopol that owns it.
I'll talk to you about that after the meeting.
Okay.
I discovered something that shows it's county.
Okay, good.
And no one is discussing abandoning lanes on the lakeside at all. And I would
Okay.
definitely oppose that.
You
We
would-
all oppose it.
I'm sure
Okay.
if there, anything would happen, it would be very black and white, what portions it would be.
Thank you.
And I think you have a strong advocate, both sides, depending on how it all turns out in the Glidden Drive Association. At least my experience from being on this board is they've been strong advocates for whatever happens on Glidden Drive, both pro and con, if you will. But I mean, I think that association's been very active in representing parties before this board, the town, and the county.
Well, thank you very much.
Thank you. Okay, let the record show there's nobody else in the audience to offer testimony in opposition. And since Mr. Walker withdrew the letter of opposition, unless any other board member, is there any other letter in opposition?
No,
Okay, then I don't think it's necessary to read that letter into the record unless others feel differently. Okay, very well, good. Okay, since there was no testimony in opposition, Attorney Pinkert, do you want to address the board on anything that was discussed this evening? Okay, thank you. That being said, then, if we could entertain a motion here from a board member.
I'll make a motion to grant.
Motion by Eric, second by John to grant. And now that allows us to work on our worksheets, so bear with us just for 5 or 10 minutes here to get our worksheets done, and then we can reconvene. Thank you. Okay, there's been a motion on the floor, made and seconded. Eric, do you want to start on the first unique property limitations
Sure.
question?
Hi, Jack. Yes, there is multiple things that we have listed, one being the wetland, we're complying with that. There is heavy slope near the house. The proximity to quotation mark platted road, which went back to 38 in this day and age, that in my mind, that road has no reason to be there and be considered platted. And the centerline setback is burdensome for the existing lot because of all the reasons of when it was platted and whatever their intent was at that time and the usefulness of it in this day and age.
Okay, thanks very much. I also checked yes under unique property limitations. The existing town road is utilized more as a driveway and not necessarily a town road, although it is platted as such. However, testimony indicated that there has been some discussion amongst town board members to address that issue. And that this particular town road only serves two properties, and to me, that meets the unique property limitation test. Joanne?
I put yes also, and my reasons were about the same as yours and Eric's. The wetlands to the north, including the septic tank, the rolling sand dunes requiring substantial fill construction on any side other than west would require excavating, and also the platted road that has not been used. It's many years old and looks like it may be, the town will not have it any longer, so.
Okay. John?
I said yes also, and everything that the three of you said is here. I just put it in a little different slant.
Okay. Bob?
I said yes as well, for similar reasons. One of the big ones in my mind was that this method of adding an addition to the house would disturb the natural vegetation at least. I think that's an important thing to consider.
Great. All right. The next question deals with unnecessary hardship. Eric, you want to address that question, please?
I went with B, checked yes. Again, a road platted in 38 with the intent of a road that really can never be developed because it's a road to nowhere. It dead ends at a wetland. Serving two properties, I think it'd be in the best interest of the two properties to dedicate it to each other. A portion or one lot absorb the whole thing, and it's not going to have a bearing on the public interest.
Okay, thanks. I too answered B, that conformity with the regulations would be unnecessarily burdensome. I checked yes. Testimony presented this evening indicated that this driveway is predominantly used by the applicant and only serves one other property. To me, that met the unnecessarily burdensome test, as that the nature of this road certainly wouldn't be developed into a everyday use by the public. Joanne?
I have yes to B, and mainly my reasoning was that the requirements of the excavating and the amount of fill that would be certainly burdensome to this, to have it constructed anywhere else.
Okay. John?
I put yes to B and said see Attorney Pinker's letter.
All right, fair enough.
I put yes to A for similar reasons that were discussed.
Okay.
Either way.
Thank you. Okay. The third test deals with public interest, spirit, and intent of the ordinance. Eric, do you want to address that question?
Sure. I checked no heavily. Like I said, I've been on this site, I've seen it, I have pretty good recall of it. These pictures that we had in our packet do a good deal of justice to it as far as showing the screening that's involved. You're not gonna see it from the road. They're not building towards the closest neighbor, towards the east or north, whatever we wanna call it. And in theory, I don't believe that what we're here for, the setback to the center line, should even come into play because of that 38 roadway that was created. It just shouldn't exist.
Okay, great. I too do not believe that the granting of the variance will result in harm to the public interest, so I check no as well. The request is a small, reasonable request that fits into the character of Glidden Drive, and importantly, will not be seen from Glidden Drive. So certainly it's protecting the public interest, and as I indicated earlier in testimony, I'm a big fan of attached garages in the single-family residential zoning district, because I think the variance goes with the property and not the property owner, and I think all kinds of trouble, maybe I'm a little paranoid, but I think all kinds of trouble perhaps happens with detached garages in single-family residential. But that's just my opinion, but certainly, I'm a big fan of these type of requests. Joanne?
I put no, and my reasoning is almost identical to both of yours, will not be visible from Glidden Drive because of amount of, that it's heavily treed, minimal removal of trees and vegetations, and I also felt that it's a minimal square amount of footage of square footage they're asking for. We're not talking a 5,000 square foot home here, we're talking around 1,500 square feet, and I think that's just a very reasonable amount.
And I think, and I'm sorry, maybe I got a little ahead of myself here too. We always indicate our
I have my numbers.
requests too. And
Do you want
Eric,
that?
well, I'll let Eric do his first
Okay.
and then we'll come back. If,
I have had a hard time with this because we skirt a lot of the issues very closely.
Yeah.
I mean, nothing really hit hard. I agree with a lot of them, I'm gonna put on the record, but the two that really hit me were 2 and 3.
Okay. And I too, under the Door County zoning ordinance purpose statement, I checked number 2, promote planned and orderly land use development. Number 3, protect property values and property tax base. I also went on and checked number 5, prevent overcrowding of the land. Number 6, advance use of land in accordance with the character. And number 12, preserve and enhance the county's rural characteristics. Although it's Glidden Drive, I still think it's pretty rural.
And I have number 2, number 3, number 6, number 9, number 11, and number 12.
Okay. John?
I said no, and see Attorney Pinkert's letter, addendum A. He
Okay.
spelled it out beautifully.
Okay. Bob?
I had no as well for similar reasons already discussed. And yes, when you want to do your,
Did you circle any particular numbers on your purpose?
No, I
Yeah,
just sort
okay.
of married them up because that's what he did.
Sure. Okay. Bob?
I have yes for the final answer, and I had 2, 4, 6, 9, and 10.
Okay. Great. Okay. Then I'll call for the.
Hey, Bob,
I'm
you
sorry.
meant, you said yes, I mean, I think, does the granting of the variance result in harm to public interest?
No, I had no for that.
Okay, I'm sorry.
Yeah.
Sorry, you're
Okay.
talking.
Okay. I think I can call for the roll call vote then. All those in favor of granting the variance signify by saying aye.
Aye.
Opposed? Motion carries unanimously.
Mr. Chairman?
Yes, sir.
One thing I'd like to include in here is 1 year to
Ah,
accomplish this.
yes, indeed. We have that on our form as well. 1 year from working with planning department staff.
Have to obtain a regular zoning permit within 1 year.
Okay, very good. Thank you all for coming on a chilly November night.
Thank you very much.
Thank you. Thank you.
Thank
Okay.
you. What a professional operation.
Yeah, I had a good teacher, I tell you.
John, I'm gonna have you write letters to me, okay, because they'll just, well, if you could do that with all of them.
When he wins, that is.
You have a contract with the drive?
Yes, sir.
If you grab those two
Yes.
11 by 17s.
Yes.
Here's the plan enables.
Okay,
Thank you.
you're welcome, thank you. Okay.
Bye,
Good night, Carl, good night. Laddie, thank you very much as well. We just have a couple of old business and announce next meeting, that's it. Yeah, okay, fair enough. Camera is on, ladies and gentlemen.
Bob, did you give the,
Oh, my sheet.
Thank you. I
Yep.
need the sheets. I would have forgotten.
Thank you, Joanne.
well, I'm just trying to.
I
I would have been had a hard time
And me.
writing minutes
Yep,
tomorrow.
and well, certainly, at least you remember my
Eric,
name
you
is.
got your turn to this?
That
Okay.
was the first one.
Item 3.0, old business, read and act on the minutes of the October 22nd meeting. I did not see any mistakes or corrections.
I'll move that we approve the minutes of the October 22nd meeting.
Is there a second?
I will second that.
Motion's been made and seconded. All those in favor signify by saying aye.
Aye.
Opposed, motion carries unanimously. Item 4.0, other matters. Mr. Brower,
Next meeting, Thursday.
Thursday.
For
2 days.
For
yeah,
most of
yeah.
you. Well, Kay will be at that one.
I'd like to ask a question about that. The packet, we've been gone for 10 days, so I just got my packet, actually at 5 o'clock tonight. Is that all new information that we've got in that packet that's this thick again?
Well, you take the old packet and the new packet and you combine the two, that's what I did. Well, I understand it.
I'm I don't know. I didn't make the packet up.
Yeah, I
I
think
haven't-
John,
I don't wanna say-
John's correct. There's a little bit of there's new information in the new packet.
Mostly
Okay.
pictures.
Mostly pictures.
Pictures.
Great pictures.
But
Okay.
I thought it was just new, but I'm not gonna say
I've been
for
over
sure.
Can they submit new stuff?
No, it's rebuttal, and it's usually, all their stuff, from what I've seen, it was rebuttal, but I
From
think.
what I
we-
understood, it's something they submitted at the hearing,
Ah,
and
okay.
maybe you didn't have copies.
That was the
of-
stuff that the girl kept bringing up.
But
I don't know. Okay, yeah.
let's ask Kay that question if we
Yeah,
have
I
any
don't-
questions.
So what we should
Or
do
if
is
you
bring all of
contact
it
Kay.
Yes.
I
on
would do that.
Thursday.
Yeah, bring it
Okay.
all.
All right.
Bring it all.
I will do that, thank you.
Bring it all. Okay.
And it's all statistical.
And if you have any questions, call Kay.
Yeah,
Okay?
Okay.
Fair enough. All right.
I
No,
really.
you're right.
Okay.
Then
Voucher.
we've got November 26th. This is another question. November 26th would be our next normally scheduled, 2 weeks from tonight. We have no hearing scheduled, but I think after tonight, we're gonna have a decision document, and hopefully after Thursday,
Yes.
there'll be
So you need
another
some
one.
signatures, huh?
So we may meet on the 26th to take care of that, or Kay and me were talking about maybe doing one of those quick afternoon meetings,
Okay,
and trying to get at least 3 of you there.
well, we'll be here.
I'll be in town.
I guess for now, all I can ask, is anybody know for sure that they can't be here November 26th? No, Eric?
And I gave you some dates and I don't recall because I don't have my calendar in front of me.
I have them written down.
Yeah, but you.
But I was,
I
It's
think-
gonna be
maybe
really
it'll be just
dandy.
a 2 o'clock in the afternoon thing again. We'll meet with 3 or 4 people and sign the
Sure.
decision
That's a good-
documents.
Sure, I'm flexible, but I just
But
can't.
I don't
whatever
wanna
it is.
totally cancel the 26th.
No.
and-
Okay,
Okay.
well, we'll have some
So
information
you're
on
not sure if
that.
it's gonna be afternoon or if it's gonna be, well,
I
We'll
don't-
get some
I'm gonna see,
information.
we'll see how Thursday goes.
Yeah, let's see how it goes.
when's Thanksgiving, is the 27th, 28th?
So Eric's gonna be killing.
It's
families?
like, this is a Tuesday, I think
Or
it's the
protect their
28th.
Following
Yeah.
Thursday?
Yeah. That's why I didn't
Doing
really wanna
vehicle
meet that
safety.
day, but.
Vehicle safety, that's a good one too.
Okay, vouchers, this is
Okay.
how much?
No.
Will we hand them in tonight?
I would say if you're gonna be there
Thursday
Thursday,
to wait?
to wait.
Hold everything then.
If
Okay.
whoever's not
But
gonna
let's-
be there, if Bob wants to turn his in.
Bob
tonight,
should turn his in tonight.
I'll
Did we
donate
turn
this
ours
one.
in from our marathon?
Perhaps you'll
You'll
be here
donate
Thursday
it.
Just to hear it. Bob.
Sure,
No.
that's not where for all the
Just,
bookkeeping.
we've been here
Is this
The direct
yours?
1 hour,
transfer.
Yes, it
ladies
is.
and gentlemen.
Although if you'd like it, you can have it.
No, I've
I'll
got.
probably make you
I've
fill
got a
out
few
more
of them.
paperwork for not filling out your
Just-
paperwork.
How many,
1 hour,
how many hundreds of minutes do we have tonight?
1 hour.
And this is just for tonight, right? Not
Yes.
the marathon.
Yes.
Did we turn in our vouchers?
No,
last
no,
Tuesday?
we
No.
But we'll add to that,
But yeah,
when
just
we
yeah,
turn
keep
it
there'll
in.
it
be 3 on
tonight
that
then.
voucher.
Yeah.
And then hand it in Thursday.
Okay.
I don't know.
But you can fill it for out for tonight, but
Yeah,
you're gonna be there Thursday,
1
right?
hour.
yeah.
So then just keep it and hand them both in on Thursday, or hand it
I
in.
probably have it with all the other
Okay,
truck.
No, I have some
okay.
lifelong friends that live on Glidden Drive, and,
There's another young on there, but they spell it with a J.
yeah, John.
Bob, did you want to fill out a voucher?
No, I just-
Wow. Okay,
That's-
I mean,
You don't want to pay the income tax.
That's right, yeah.
good lord, I knew John Young would come up with that. All right, fair enough. Motion to adjourn.
I so move.
Motion by Joanne, second by Bob to adjourn at 7:30, because we played ourselves 1 hour.
Well, why can't we just do it in this room for the?
We're done. You can turn it off.